they are abusing the process. They are the ones abusing the process. And their powers under Article 157, they are not acting in the public interest and in the interest of administration of justice. In fact, the reason offered, the reason offered by the learned ODPP, I would just, short of calling it inept, if you look at the charges, they concern conversion of 3 motor vehicles from the administrator appointed to oversee the company. There is a very elaborate process of arriving at a decision to prosecute under the national prosecution policy. We haven't had our learned friend say when they reached the Damascus moment and decided to change tact. Actually, even reference to the insolvency petition is totally misguided. For good order, the administrators was interrupted in his exercise of the duties and is a witness and is also the complainant before court. If you look at the pattern of the DPP in this matter, it has been wanting. And if you look at your record, on 30th of January last year, 2024, a similar groundless application was made, which led to the discontinuation of proceedings against the first accused person. That accused person. Now, at the time, what was the reason offered is that it would delay the expeditious prosecution of the case. The third accused person, and I say this, is the one who conspired with the first accused person to, according to the charges, to convert the 3 motor vehicles. What is most sad is that today being 11 on 9th, a pre-trial was held with the witnesses who are in court today. They are present before court, ready to testify. But if you hear from my learned friend from the prosecution, this letter is alleged to have been issued on 14th of May, meaning that she was not privy to that decision. Similarly, the investigating officer never told us that there is any such decision. When the decision to withdraw the charges is made and there is a victim, in this case the complainant, respectfully that person should be informed and also given the reasons. This cavalier and casual way of interfering in the criminal justice system, it is starting from the National Police Service. The court can take judicial notice of the events happening in the country. And the worst thing is that it is also going to the office of the DPP. With all due respect, the current holder of the office must also be stopped from extending the abuse of criminal justice system. Apart from being incompetent, he's coming to shield suspects from facing justice. It is not for us in this matter to discuss whether he should be impeached, but this is a clear case of somebody whose sole mission on earth is to defeat criminal justice system. We have suffered on that year of January 2024, and people say lightning does not strike twice. Here it has struck again. We tender 3 decisions. We are always armed with them because the ODPP this is the biggest threat to the criminal justice system. And I'd like particularly to rely on the second decision by Lady Justice Martha Koome. That is the case of Republic versus Enoch Wekesa. I've flagged it for your honor. And the primary consideration should be the interests of justice and public interest. And she found that the ODPP cannot just casually break up and withdraw criminal cases and defeat the cardinal rule that there must be justice for all. We do not want to speculate what may have happened behind the curtains. That is beyond us. But we urge Your Honor to stand firm. We have cited 3 decisions. And in all circumstances, the courts stood firm, and particularly the first 2 cases, Ahmed Rashid versus DPP and DPP versus Enoch Wekesa. I'm sorry to say the witnesses are present in court. I think my learned friend is appearing in this matter for the first time. Mr. Kaka, I do not want to insinuate anything. I believe he was just the beneficiary of new instructions. We urge you to stand firm. Who will protect Kenyans other than the courts? Who will protect Kenyans from the abuse of office by the National Police Service? Who will protect Kenyans from abuse of office by constitutional bodies such as the ODPP? Your Honor, you have the answer. The witnesses are present. Just to finalize, this matter, there was even accused 3 whose case was withdrawn again by the ODPP, had even been ordered to be extradited to Kenya. Such is the faceless and gross insensitivity of the ODPP that a witness whose the UK government had agreed to extradite to Kenya, they gave him a golden ticket to fly away. Just when we've caught the bird, they removed the trap. What role are they doing in this matter? They are tinkering with the justice system. They are bringing down the Republic of Kenya, and we urge you to dismiss this request. The prosecutor was not even kind enough to say she has 2 witnesses in court. I'm sorry, I'm embarrassed to say I'm the one saying they are present, and I request them to stand so that it doesn't appear to be a casual reference. They were prepared. These are people who are also seeking justice. He is the administrator, PW1, the complainant. Today would have finished with 25% of the case of the witnesses. What is the ODPP fearing? What did they find that made them? My humble submission is that it's not an accident. It's a treasure hunt, this one. But these are competent witnesses. They cannot be interfered with. They'll be able to explain their case. About this debate.
Since there's an opposition to the withdrawal, we'll have to hear both sides, then the court will make a ruling on the determination whether the withdrawal is justified or not. I believe we've made a fair request to be supplied with the authorities which have been cited by counsel watching brief for the complainant. The same can be supplied to you, then we can agree. We come back, we canvass our our arguments, then we can have a date for ruling for the court to make a determination.
Very well.